For millions of us, living in a community with a homeowners association or an HOA is just part of life. But what happens when the rules go from being a minor annoyance to sparking an all-out legal war? Well, we're about to dive into one homeowner's absolutely extraordinary battle with his HOA. This wasn't just one complaint. It escalated into something you almost have to hear to believe. I mean, really, think about that question. What happens when you sue your HOA 6 separate times? It sounds like a joke, right? But for one homeowner in Arizona, this was his reality. He didn't just have 1 or 2 grievances. He filed 6 distinct cases against them. So how on earth does a neighborhood dispute get that far? What were they even fighting about? And when all the dust settled, who actually came out on top? All right, so here's how we're going to unpack this whole thing. We'll start with that very first complaint, watch how the cases started to pile up, and then we'll get into the nitty-gritty of all 6 disputes. After that, we'll look at the judge's final verdict and, most importantly, talk about why this one case really matters for anyone living in an HOA. You know, every massive fire starts with a single spark. And for this one, it wasn't some big, dramatic fight over a fence or loud parties. Nope. It all started with a single, really specific financial issue: fees for the community's septic system. And this wasn't just a battle of angry emails or awkward neighborhood meetings. No way. This was a formal legal challenge taken to Arizona's Office of Administrative Hearings. This is a special court designed to handle exactly these kinds of fights, so things were official from day one. So who are the main characters in our story? On one side, you have the petitioner, a homeowner named John Krahn, who was eventually joined by some of his neighbors. And on the other side, the respondent, the Tonto Forest Estates Homeowners Association. It's that classic homeowner versus HOA setup, but as you're about to see, they took it to a whole new level. That first complaint about the septic fees, yeah, that was just the opening shot. Pretty soon, other issues started bubbling to the surface, and what began as one single case started to snowball into a really complex, messy legal marathon. You can literally watch it escalate right here. The first case gets filed in January. By October, the judge is looking at this growing stack of paperwork and, to save everyone time and money, basically says, okay, we are not doing this 5 separate times. So he consolidates them into one mega case. And by the time the final hearings rolled around a few months later, a 6th case had been added. The court was now dealing with all 6 issues at once. And this brings us to the heart of it all. What were these 6 fights actually about? Well, they were all over the map, from big picture financial stuff to tiny but crucial procedural rules. Let's break down every single one. Okay, dispute number 1. This is the one that started it all. John Krahn and others owned empty lots in the community. Their argument was pretty simple. The HOA was charging them septic fees, but the community's own rulebook, the CC&Rs, said those fees were only for lots with dwelling units, houses. The HOA's take was that, well, their interpretation was that every single lot had to pay up, house or no house. So what did the judge say? A clear win for the homeowner. And the reasoning here is so important. The judge found that the community's own governing document wasn't vague at all. The wording was perfectly clear. No dwelling means no septic fee. That's a huge first victory for the homeowners. The second dispute might seem kind of small. It's over just $75. But for the homeowners, this was about the principle of the thing. The HOA had paid a board member back for a septic part. Mr. Krahn pointed to the rules, which said the HOA covers repairs, but homeowners are on the hook for replacements. He said this was a replacement part, plain and simple. The HOA argued the invoice was a bit fuzzy, so they just used their best judgment. And again, the judge drills down into the details. The finding was that the part in question was, in fact, a replacement, which means the HOAs should not have paid for it. Another win for the homeowner, hammering home the point that even tiny financial decisions have to follow the rulebook exactly. All right, dispute number 3 shifts gears from money to pure procedure. Mr. Krahn got a notice about trimming a tree. He argued the notice was totally invalid because it didn't say what specific rule he had supposedly broken. The HOA kind of brushed it off, calling it just a friendly reminder and promising they'd fix their process for the future. Well, the judge found that even a friendly notice has to follow the rules. It didn't tell the homeowner what he needed to know by citing the specific rule from the CC&Rs. The lesson here is huge. An HOA can't enforce a rule without clearly stating what that rule is. That's another win for the homeowner. This next one really gets to the core of community democracy. The HOA's rules required a secret ballot for elections, but after the vote, the HOAs stored the ballots right alongside the envelopes that had the voters' names on them. Mr. Krahn argued this completely destroyed the whole point of a secret ballot. The HOA's defense? Well, the bylaw didn't say anything about how to store them. The judge's logic here was just pure common sense. If the vote itself has to be secret, then it would necessarily follow that you have to keep it secret during storage. The anonymity doesn't just vanish once the vote is counted. This was another clear win for the petitioners, setting a really important standard for how to run an election. Okay, now here's the one time the tables turned. There was a whole other lawsuit going on where Mr. Krahn was suing the board for defamation. So, to get lawyers, the board met in a closed session and decided to file a claim on their insurance policy. Krahn argued that's a financial decision that had to be made in an open meeting. The HOA fired back, saying it was all about legal advice and ongoing litigation, which the law allows them to discuss in private. And on this point, the judge sided with the HOA. Because the decision was so directly tied to that pending lawsuit, the board was well within its rights to not only discuss it, but also decide on it, behind closed doors. This was the one and only dispute that the HOA won. The final fight was all about transparency. Mr. Krahn put in an official request for copies of other tree trimming notices the HOA had sent out. The HOA blew past the legal deadline of 10 business days to provide them. Their excuse? Their lawyer told them not to hand them over because they were part of the ongoing litigation. The judge was not buying that excuse for a second. The ruling was crystal clear. The HOA wrongfully withheld the records. These were just standard notices sent out long before this case blew up. They weren't some kind of secret legal documents. The HOA couldn't just use litigation as a magic word to deny a member's basic right to see the records. So after 6 different legal battles all rolled into one massive case, what does the final scoreboard look like? It is an absolute landslide, 5-1 in favor of the homeowner. On finances, on procedure, on transparency, the judge ruled again and again that the HOA had failed to follow its own rules and the law. And this victory wasn't just on paper. For those 5 cases they won, the HOA was ordered to pay the homeowners back for their filing fees, adding up to $3,500. That's a real financial consequence and a very clear message from the court. So why should you care about this one story? Well, first, it's a powerful reminder that the exact wording in your HOA's rulebook is everything. Second, procedures aren't just suggestions. The rules for how notices are sent, how votes are handled, and how records are kept have to be followed to the letter. And finally, it proves homeowners aren't powerless. There is a formal legal path to hold your HOA accountable. This whole saga really leaves us with one critical question, and it doesn't matter if you're a homeowner or a board member. After seeing how one determined person can challenge an association on the tiniest of details and win, you have to ask yourself, are my community's rules and procedures clear and strong enough to actually stand up in court?